with us today. I'm sure you'll enjoy our State Attorney General, Sam Olens.
Good morning. How Charlotte Nash is a newbie's beyond. Sorry. How Charlotte Nash is a newbie's beyond me, but and of course, so you got one guy, Billy Coker, who's about 83 and a new time commissioner again. But so it's a pleasure to be here. Charlotte's a great lady, so I unabashedly am a big fan of Charlotte. When I was chairman of Cobb, she was the county administrator for Gwinnett. And at that time, there probably was not a county that you would want to visit more than Gwinnett for their processes. And of course, I was partial with Cobb, but she just did a fantastic job as their administrator, and it's great to have her now as their chairman. So 14 years ago, I was in your seat. Unlike some of you, 14 years ago, I didn't think I had all the answers. One of the things that concerns me is the folks who get elected who decide because they were elected they know all the answers. And one of the ways I would see that the most is the new commissioners would show up to their first town hall and they'd answer all the questions and you'd have the staff in the room going, oh, blank. So let me suggest to you, first off, admitting to your citizenry that you don't know all the answers is a good thing. It's also honesty. Relying on your professional staff is a good thing. If you find you can't rely on your professional staff, then they shouldn't be there. But until they prove otherwise, listen to them, especially, I might add, your county attorney. So by definition, one of the things, I always used to love that whenever we'd get new commissioners, the first thing they do is, well, I promised folks, as Ken was talking about, who's an outstanding local government lawyer, your prior speaker, I promised folks I'd introduce ordinances. And you'd say, and you never thought in Cobb County's history we ever thought about that idea and decided it was a real terrible one? Because keep in mind, for those commissioners that are elected in a part of their county rather than countywide, what may work in your part may absolutely be terrible in other parts. And even though you're elected by a part, you're there to represent your whole county and to do what's best for your whole county. So it's really important that you walk into the position in January willing to listen. For instance, I had a commissioner that wanted to deal with the size of the lots. And what was good on the west part of my county was absolutely atrocious for the Vinings part of my county, both unincorporated. And you'd sit there and say, you can't do that. And then they'd say, well, Fulton County, and I'm pretty blunt and pretty candid for the 5 of you that don't know that in this room. So they'd say, well, Fulton County has specific ordinances for part of their county versus other parts of the county, so didn't that solve the problem? Well, the answer is that's why there's all the damn new cities in Fulton County, because the people felt like they should all be treated the same rather than little favors given for different parts of the county. So A, it's a pleasure to be here. We're here to talk about transparency, accountability. Let me suggest to you that old thing called the golden rule works really well in government. Let me suggest to you that before you press the reply key on an email, take a deep breath and think before you reply. When I first was elected to Cobb County, we had a bus system from hell. Condensation, the folks would get wet in the summer, the heat wouldn't work. If it was supposed to come every 10 minutes, it came every 30. We ended up firing the company and getting it under control. But we got a lot of emails and calls from folks that were really mad that the bus service was messing them up with being, God bless you, with being on time to work. And I would press reply and I would say, I'm sorry, we need to do better, we're working on it. Now, once in a while, you'd get yelled at a second time after you press reply, and then you'd press delete. But most of the time, you really don't need to press reply. You should press delete, because what you want to reply will get you in trouble. And if you're going to reply, use sugar. Now, having said that, 10 years later, when I was running statewide, one of the guys that was the most vocal against our bus system ended up having a brother who teaches at Valdosta State University. He ended up being the head of the campaign for me in Southwest Georgia. And it wasn't that his brother and I ever agreed on the issue. He just respected the fact that I gave him time, that I gave him the courtesy to listen to him. So I would suggest to you that, one of my mentors is Johnny Isaacson. He's been my state house member, my state senator, my congressman, your senator. He's the same Johnny now as when he was in the Georgia House. And he meets with folks that totally disagree with him politically, but because he gives them time on those federal issues, they don't protest outside his office. They don't publicly criticize him. They agree to disagree, and with that agreement comes a passivity. And there is nothing closer to the people than the job you have, whether you're a mayor and council or a county commissioner. Just giving people that respect. Now, I know that's technically not accountability and transparency, but let me suggest to you it really is. Because the way the people perceive you is the way they perceive your government. Similarly, I used to love when we'd have a police chief or a fire chief that had a great aura around them. Because your police officers and your firefighters are who most of your citizens see. They don't see you. They don't see the head of your library system. They don't see the head of your senior community center system. They see your firefighters and they see your police officers, and they see them generally at a time they don't want to see them. And if you can convince them that customer service includes that public safety component and they smile, you'll be the one on the ballot they want to vote for re-election, and you didn't do anything, but you had folks that they come in contact that they have a positive impression of. Y'all follow me? So let's see if we can get this to work. So first of all, we passed last year House Bill 397, which is the Sunshine Laws, open records, open meetings. Now let me first suggest, and we had a lot of great help. We had Jim right over here that spent an awful lot of time with us, the attorney for ACCG. And towards the end, when I actually convinced folks the bill was going to pass, rather than I was Don Quixote swimming upstream, Jim and Marcy from GMA and the AJC lawyers and all spent a lot of time looking at the sentences in the bill and working to improve the bill and to get everyone on the page. We had a meeting that Ken Gerard was at where it was great because I got the county commissioners to yell at me because I was doing X, and then they had the AJC going, well, damn right you need to do Y. And it put all of them in the room, and they understood that I wasn't so much the villain as the one trying to do the balls and strikes. And of course, Clint, who does a fantastic job for this agency, at the Capitol. I keep seeing your picture in the paper lately with your state senator. Clint does a great job at the Capitol. I only mean that as 100% positive. He protects your tail big time down there. But by getting everyone in the room and seeing everyone's concerns, there were at least 3 or 4 sizable areas where it got resolved to everyone. Everyone could live with it. And I just took the fact that I needed everyone in the room to hear each other out, which is a good overall issue for you. Because when you're dealing with your citizens, there's only so much you could do with one segment versus the other. You really need to get them in the same room with you. And then to work on a compromise where everyone still maintains their principles, but everyone knows it's better than it could be if you just unilaterally made a decision or made a suggestion to your board as a decision. One of the things that came out the most in this process was folks would call me up or they'd yell at me and they'd say, well, you're making us do X, Y, and Z for open records or open meetings. 90% of the time I'd get that comment, I'd be able to tell them, no, ma'am or sir, that's been the law for the last 25 years. That's not one of the sections in this bill we changed. So the first thing I need you to do is that God forbid thing, which is read the damn bill. Read it. Ignorance is not an excuse. If you have questions over it, talk to your county attorney. If your county attorney isn't familiar with what this bill is, you have other issues. Okay? I'll bet you Ken Gerard, for example, can sit there and, quote chapter and verse on some of the sections. That's what your county attorney is supposed to be able to do. There's nothing that affects you more, except for ethics, than this bill. You need to know it. It's fine for your lawyers to ask me questions, and we'll cover that at the very end, but you need to read it. I might suggest you better read the ethics legislation that relates to you too. You don't get an out on that one. Ignorance is no excuse. So clearly you don't need to read ACCG, Georgia law, but those parts of the law that affect you the most, you better read. Give yourself a summary. Ask your county attorney to give you a summary that takes it from legalese and puts it in English. We tried our best to put this in English, but clearly that, lawyers have that disability, so we try the best we can. But read it. Familiarize yourself with it, both the open records and open meetings. I have about 4 lawyers in this section. My life doesn't need complaints from your citizens. I get over 400 complaints a year. I got 4 lawyers in the section. The more you follow it, the happier I am. Now, we serve a mediation role where we will try and resolve. And the vast majority of time, we do resolve. When the Cherokee School Board decided the charter school folks had to pay $10,000 for X number of pages, and they hadn't even figured out how many pages, the next day it was about $100 when we made a call. So we will strive to resolve problems. If you have a problem coming, calling my office up front and saying, can we meet with you, show me how to solve it, we'll do that. It's less time for us on the front end than the back end. We're there to help. One new commissioner went up to me and said, well, I really want you to come to my community. I just want you to come without a cause. Give me a call with the problems on the front end. Make it easier for you. Make it easier for me. Now, if it's like one government that tells me where to put it, there's a lawsuit against that government now. And under Georgia law, the fine isn't much, but I get legal fees. Those legal fees are going to be 6 figures. And I certainly hope it's in their budget because I'm winning that lawsuit. So read the bill, count on your county attorney, lean on your county attorney in general. Your county attorney is one of the few people you'll talk to that isn't interested in your vote in return. Similar to your county manager or county administrator. They're not looking for something in return. They're looking to keep all of you out of trouble. Okay, an agency, and Ken touched base on this a little bit before when he was talking about public records. If in doubt, assume you are. Clearly, county commissions, development authorities, any board you appoint at a public meeting is a state agency within that definition. Just assume it is. So, for instance, you can't go and exec and decide who you're going to appoint to your boards. That's not executive session. Not at all. 0. Happens all the time. It shouldn't. It can't. If you give money to a nonprofit or third party and that is over a third of their budget, it is now an agency. The law before had a different definition for meetings than records. One of them said greater than a third. One of them said in a significant amount of money. Representative Jay Powell, who was the chief sponsor of this bill, who was the former mayor of Camilla, a great guy, said that's silly. We got to have the same language in both the records section and the meeting section. So now more than a third. I would suggest to you I have files in my office now concerning this issue without looking at those folks that it relates to because they know it. A meeting includes a quorum. The old law was ridiculous. The old law said it was only a meeting if it was properly timed and noticed. Now follow me. That means that if y'all decided to go to a private room and it wasn't timely noticed in time and with the place, the location, it technically wasn't a meeting and you could get away with it. Bad government. So the new law says, if y'all meet to discuss business, I don't care whether you do an agenda or not. It's a meeting, you're going to be having an issue. Gooms v. Irwin was the ridiculous case that said that if you didn't cite the time and the place, it couldn't be a meeting. So that was one of the changes we needed to take into account. There was a case involving the city of Atlanta where they would say motion carries because they were too chicken to say who voted for and who voted against. You know, you won the seat. The public has the right to know whether you voted for or against. And by the way, some governments let individuals recuse themselves without a legal basis per those guidelines to do so. Y'all shouldn't let that happen. You have a definition in your community, in your policies, whether it's legislative or by a local law, that says when you can recuse. Folks shouldn't get an out when it's a controversial issue and they don't want to make someone mad. If they don't have a pecuniary interest, if they don't have a legally cognizable conflict, their tail ought to be voting. So the change says they have to vote. Now, there was a case involving Bibb County that caught all of us by surprise. And that was a case that said you could decide real estate acquisitions and executive, which was totally against the intent of the old law. So what we did, in working very closely with GMA and ACCG, is we sat there and said, look, governments need to have those discussions about how much you'll offer for a piece of land. So what you can do in executive session is you can authorize negotiations at given prices, but you need to have the final vote in public to consummate the deal. It's the way Cobb County did it before. It's easy to do that. So you get to be an exec, you get to say, okay, talk to their lawyer, you can give them up to 125, that's it. If you get them at 120, then you save the citizens money, etc. And then when you do the agenda item, you can't be cute. You can't say motion to purchase land. It has to be motion to purchase land at 123 Main Street for 3 acres at a price of. The public deserves it, and the new law requires it. But everyone agreed that the way that we changed it, and what we did, which was really good for local government, before it was only on acquisition, now it's also on leases. Now it's also whether you're the one buying or the one purchasing. Either way, the government's protected in this fashion. And another change that ACCG wanted, which is the bottom of this page, is to make it clear to what we all thought was common sense anyway, but not in the act, that mediations were not open. That when you have a lawsuit and you have your attorney or you have some of your elected officials, that the public doesn't get to be in on those negotiations. You clearly have to have a vote at a public meeting, but the negotiations need to be confidential, need to be private. Now, there was a split between ACCG, GMA, and my office historically on the first bullet of whether or not you could interview folks in executive session. The documents are absolutely public. There is no issue there. But there was an outstanding issue about whether you could interview an executive for senior management. Well, once again, I was in your shoes. I thought it was really helpful to be able to interview folks in executive session. So I convinced my folks that I was the AG and that law was changing. So we now in this one of the good things that y'all got was the finalists for executive offices can be handled in executive, but you still need to have a public vote before you retain that individual. We also, another change that we did is, you can have a record, you can have a document, and a part of it could be on an exempt issue, an issue that shouldn't be made public, but the other 8 pages may be public. You can literally go into executive session to cover only that part of a record that is exempt, so you're still protected. But once you're an exec, don't start talking about the other 8 pages. Talk about the part. So that's a nice protection for y'all that you didn't have before. Now, one change here, and your attorney and I have talked about, I honestly don't have strong feelings. So that's the bottom line from your perspective. You know, the press wanted your executive sessions to be videoed. And I ended up with a whole series of PolitiFacts where Clint helped me because I made a comment in an Atlanta Press Club meeting that there's a digital divide in Georgia, that not all governments have email, not all governments have websites, not all governments have video equipment to be recording these things. And of course, the AJC thought that everyone had what the city of Atlanta had. So GMA and ACCG actually helped me with that one. So the compromise after getting everyone together was that your clerk will take minutes of executive session. The minutes do not need to include any comments by your county attorney, as that is protected, and they are not public. They stay out of the public eye, but if a citizen sues your government on the grounds that you had an executive session for an inappropriate purpose, the clerk would then send those minutes to the judge for what we call legally in camera review, which is the judge sees those minutes, but it's not part of a public record. And the only time the minutes would be made public is if the judge found that the purpose of the executive session was inappropriate, that it was a violation of the Sunshine Laws. Now, ACCG's asked me some good questions, such as, should the commission ever vote to approve those minutes, and how do you do it because the public isn't seeing the minutes you'd be approving? I honestly don't care what you do or what you don't care. I just wanted there to be minutes as part of the deal we made with the press. I'm sure Jim will tell you that if you have a mechanism to approve it, it's probably better for you from a legal perspective. I don't disagree with ACCG's attorney, but from my office's perspective, whatever you do in good faith, we're going to support. So we're not there to be a pain in that position. So there's been a lot of questions. Now, historically, my office only had criminal jurisdiction, not civil jurisdiction. Once again, being where you sit, I wasn't really happy with that for two reasons. Number one, there were a lot of problems that my office didn't want to go after because it would be too hard to meet the criminal burden. That went in your favor. The other problem was you don't really want me filing a criminal process against you. So, but for a government that chooses to have a big fight with my office, but for a fact pattern that's really extreme, why do I want to be subjecting you to a criminal warrant? I just want the matter resolved. So we were able to work on giving me both civil or criminal. Civil is a negligent standard. Criminal is a knowing and willing standard. It's my discretion. The fines were $100 and $500 for records and meetings. Now they're $1,000, but if you've had a fine within a year, it can go up to $2,500. Let me ask you to assume that a lot of times if you make a mistake, it could be more than $1,000 at that time where you violate several things at once. As I said, we only have one lawsuit pending against the government. They asked for it. And by they asked for it, I mean the mayor of that city literally at the next meeting after he made the screw up that was based on old law, had someone call him on the phone and said, yes, the attorney general may be calling. I don't really care what he does to me. Lawsuit. I can have a sense of humor, but I can respond, you know. The other thing, if a county inadvertently takes an action without a public vote, 90 days was really not a sufficient amount of time to try and reverse that. By the same token, there were folks in the press and otherwise that thought you should be able to go back no matter how long. 6 months seemed like a nice, happy medium there before you run into a lot of contract issues. So that's open meetings, and I'll be happy to take Q&A on it. Open records. For the first time, we have a section on strong legislative intent that your record should be public. Without delay. When in doubt, provide the records. And we did a lot of negotiation in these areas. Areas where you got a gain, area where the press or the public got a gain. There was a whole set of bargaining here. The last one, you know, state law relates to you on retention of records. But you'd be amazed how many governments, they keep their emails for 30 days, 60 days, 90 days, forever, 2 years. That act tells you how long your documents need to be kept. And because most governments claim they didn't know there was a state law on it, we specifically reference the state law now in the act. So once again, go up to your county attorney for memorandum, for documents. How long is it required by state? Make sure they follow it. It only protects you to follow the law. One of the things that I thought was neat that we did, that the governments liked, you know, I used to love it when someone would go up to a fire station, ask for records that had nothing to do with the fire department, and then the citizen would say, well, it's been 3 days, where are my records? You don't even know if the request got to the county administrator in 3 days. So what we said now is you can still ask for things orally, but you can't seek enforcement unless you do so in writing, which was a nice compromise for both sections there. So they cannot take enforcement action. I cannot take enforcement action unless there is a written request. Now, you'd be amazed how often a citizen will send a letter to you asking for records and you tell them no thank you, and I send you the letter and you tell me no thank you. A different response would be helpful. It can be email, it can be faxed. You can ask for an open records designee. You have to do that at a public meeting. I have no clue why every government would not do that. Because if you sit there and say, I'm going to have the person in charge of county communications, the person who's the PIO, public information officer, the county manager, that's who you send that to before the 3 days starts, you're protecting yourself. So from my perspective, I don't have a clue why every government in Georgia hasn't done that. Now, if they're on vacation, whoever's sitting in and watching their desk over those days still has the 3-day rule. If they go to Paris for 2 weeks, it's 3 days from when it comes in. It's not when they return from Paris. But I thought that was a real big win for local government. You can charge a reasonable charge for the search, retrieval, and redaction. That was a big win for governments because you couldn't charge for redaction, and the press and local governments were fighting on what you could and couldn't charge for. And that was really a bargaining chip with the second bullet, because one of the things that the press disliked the most was you could still charge $0.25 a page. And we all know it doesn't cost $0.25 a page anymore, like for the last 20 years. So it's now a dime. It still doesn't cost you a dime. If it costs you a dime, you need to talk to your purchasing department. So we had that partnership there. Now for documents, God bless you, that literally cost you more than a dime, you know, you have a big sheet of paper, you got a big plan, it's, you know, you charge the cost. What it cost you, you charge them. No one gets ripped off in that proposal. And keep in mind, less and less are you going to be giving people paper. More and more, you're going to be clicking the email. Now, the person who's doing the request for you, they get the first quarter hour free, the citizen, and then you're able to charge their hourly rate, but you have to show that it took that level of competence to do the request. So for instance, if it's a request for the last 6 months of minutes, there's nothing to redact, there's nothing to do except push copy on the copy paper, that ought to be a really cheap employee. If it's something that involves law and you need to make sure your county attorney looks over that section, the part that relates to law, you can use your county attorney's legal rate. If part of the request has a legal and part of the request doesn't, then you have to divide them. You know, I just got someone went up to me again last night that they went up to a government. They're told it's going to be like $1,000. And they were told it was 200 pages. Well, 200 pages times 10 cents just doesn't come to $1,000. So you got to be reasonable. It's 3 days. It's not 3 days from when you want to do it. It's 3 days. And one of the things that we changed is if you have some of the documents now, but some of the documents are in a warehouse, what used to happen before is people would say, I'd get back to you. Well, that and a cup of coffee went far. So what we say is, give them what you have now within the 3 days, but give them a letter within that 3 days that says, and within 10 days, 2 weeks, whatever, I can give you the rest. And one of the changes we made that was really good for local government, if you look at the last bullet, how can your county attorney tell you the legal objections on documents he or she hasn't seen because they're in a warehouse? We were asking the county lawyer to put the full set of legal objections on stuff that he or she hasn't seen. So we said now, within 3 days from when the records are in your possession, the lawyer can then tell you what the appropriate legal objections are for those parts of the documents that shouldn't be released to the public. So that was once again a common sense scenario that worked for local government. We had a lot of discussion about what happens to the professional person who asks you for records and never pays for them. And it's a very difficult issue. So what we ended up doing was if the request is for less than 25 grand, you immediately give it to them with an invoice. You don't tell them payment up front. If it's $25 to $500, you have to tell them, and I would suggest by email or letter, it's going to cost $183.24, and they need to write back to you, thank you, I'll pay. Not that you get the money up front, but you have their commitment of payment. If it's over $500, ask for the check or cash up front. Because your government, whether we're in a recession or not, does not have the authority does not have the ability to have thousands and thousands of dollars of outstanding bills. So is there anything special about $25 and $500? Not that I could figure out. We went through whether it should be 100, 200. That's just where everyone ended up. And when Jim would be in the room and Clint would be in the room and Ken would be in the room, I'd say, guys, I can deal with any set of numbers. Just agree on what you want. And that's where we ended up. Now, if a prior request hasn't been paid, whether it was for $15 or $300, you can't tell them that you will not complete any more requests, but you can tell them all future request payment needs to be had up front. So it limits your loss. Now you can have your county attorney file a lawsuit in magistrate court to get the money from the one that they haven't paid, but they can't do request number 2, request number 3 until they've paid the outstanding bill or they got to pay up front. And I think once again, that's a nice thing for local government. And I'm specifically referencing the things that you like because you've heard all the things that some people don't like. You can't tell someone the information they want's on the website. You got to do a little bit more work than that. Now, if you tell them we're on the website to get it and they say, no problem, I got it, then don't do more. But if it's someone who doesn't have sufficient computer skills, you got to give them the copies at that point. You can't just say it's on the website. We had an issue recently with Fulton County where they had a vendor and they'd go back and forth blaming each other for why the AJC couldn't get records from a perspective of how it all worked with the confidentiality and all. A government doesn't get an out to say it's the vendor's fault. You contracted with the vendor, you got to solve the problem. And that's a common problem that we were getting where the vendors came up to us and said, now hold it, we're being blamed for stuff and you're assuming that the government's called us versus just blaming us. So now it's the government role. We had a case involving Atlanta Public Schools where they were very creative. There's a section that says if you're the subject of an investigation, there's a pending investigation section where governments don't give out records if there's a pending criminal investigation. Well, the City of Atlanta school system decided that since they were the subject of the investigation, they didn't need to give the AJC the records. Wrong. It's the law enforcement agency that has the exception, not the subject of the investigation. So we cleared that. We also made it much easier on bids and proposals. If you literally looked at the old statute that no one did, it only related to public works projects, but governments were using it for all RFPs. And there was a glaring problem with that because if someone once again read the statute, y'all pretty much had to give out stuff you didn't want to do. And that was a nice resolution. Okay, this is the last set of slides I have on this one. In Cobb County, we had a situation where people would give us their email and we'd give alerts like, if you were in Zone 1, tell them about the crimes in Zone 1. If you were in Precinct 2, we would tell them about the crimes in Precinct 2, things to look out for. We would tell women Christmas time, put your purse in your arm, don't leave it in the shopping cart at Target, that type of thing. Someone asked for a copy of all those emails. There was nothing in Georgia law that made those emails privileged, which was wrong. It discouraged the public from helping you on law enforcement. So we would go to the legislature. We would get a law that said that when it related to public safety, you didn't have to give out the emails. Well, you didn't need to have a section every year on a new problem. So now we have a section that literally itemizes. You're not going to give out people's social security numbers, their mother's birth name, the credit card info, financial. This relates both to your employees, your past employees, citizens. No one has the right to have their privacy blown away because there's an open records request. A lot of governments run utilities, water system, etc. We'd have companies that wanted to get the records on our water system customers so they could then abuse it and bother them to buy their products. That's not what government's about. So all this type of stuff nowadays is protected, which is the way it should be, because if there's one thing we have a lack of, it's privacy in this country, and so that was a good section. Attorney-client privilege, let's talk about the last one. You will have times when your government is involved in investigations, whether it's a sexual harassment claim, whether it's a theft claim, and there was a glaring gray area, what you needed to give and what you didn't need to give. The local government lawyer said you needed to give nothing. The HAC said you had to give everything. So what we said is that the factual findings are discoverable, but the legal analysis is not. And that's what governments were most concerned of, is that if your county attorney says you have a real problem here and you need to settle the case, that needs to stay privileged. But the facts that are disclosed in the investigation are public. Now, one thing that my office, that's the same for open records. One thing that I've done that's new for our office, if you and your government have a question about state law, and I'm not going to assume that what they pass at the legislature is always clear and obvious for where they're coming from. If you have your attorney put in writing, this is the concern we have, this is where I think the law is on that subject, and if you send it to me, in all likelihood, we will respond and tell you whether we agree or disagree with your lawyer. We had a situation recently with the city of Canton and whether or not they were using a fee or a tax hike to deal with a fire fund. So the mayor was on one side of the issue, the city council was on the other side of the issue. The city attorney, on behalf of the city council, wrote a letter saying they think it should be X. The mayor, of course, needed to send me his own letter telling me he thought the answer was Y. We ended up siding with the mayor based on Georgia law rather than the council. But before, if you were a sheriff, if you were a county commissioner, if you were a councilman, and y'all had a concern about state law, we'd sit there and say, we don't represent you. We represent the executive branch. But I think if you in government have a concern about state law, we can do a little bit more to help you. So we require that you have skin in the game and that your lawyer opine what they think the answer is, and then we will respond. And we do that on a regular basis now. Now keep in mind, it's a public record. If you send it to me, it's a public record. The fact that it may come from your lawyer doesn't mean it's confidential. You're asking me a question about state law. It's a public record. And at this point, I'm happy to take any Q&A that you have on the issues. The long and short of it is, you know that old adage, don't do anything that would embarrass your mom? It works when you're elected too. And I have the same problem. I do stupid things also. God knows my office tells me every time I do. So ask. Yes, sir.
Hey, Sam. Tony Center, Chatham County.
Hey.
How you doing?
Doing
This
well,
wants to
very
blend a
well.
little bit with what Ken said. You're using your personal emails and you may discuss personal stuff to something,
Right,
county stuff and other stuff. Somebody wants an Open Records Act.
right.
Am I individually responsible to do the first sifting, and do I charge for my time in doing that?
Okay. So this is my impersonation of a sheriff. This is state, this is personal. If you start using your personal email on state business, those emails are public. Now, I'm not saying all of your emails are public. The ones that relate to not state business, county business, government business. If you think you're cute by using a personal email on state, it's disclosable. So for instance, we see it pretty regularly. Because what happens is, let's say on your county commission, it's a 3-2 vote, and the two figure out that you all were talking about how you were going to vote on an issue. Guess who gives you away? We had an issue near Tony with numerous issues with the city of Savannah near Tony. The councilmen on the wrong side of that deal were the ones who told us exactly what was happening. So people will say, how do you know? It's really easy. The people with the minority vote are calling my office. Okay? So we had a situation with Cobb County School Board where they were using their personal emails. Now, this isn't a case of a government that didn't give government emails. They intentionally were using personal emails. All of those personal emails. Now, if a request is made by a citizen and they're asking for personal emails, don't give it. If they're asking for any personal emails that relate to government, then frankly, you need to have a talk with your county attorney, and you need to make accessible to your county attorney those emails. And if the person sues you in court claiming that you're not responding to the Open Records Act, then it's for the judge to decide whether or not he wants to get all those records from your phone carrier at that point. So it's not that your personal emails are all then public. It's that any and all of your personal emails that deal with a public issue are a public record. But it just gets messier. I mean, then you got to have someone looking over your emails. The county attorney, I mean, I don't really want them to know what time I'm having dinner with my wife tonight. So I try my best. So for instance, people, they know me from my prior 12 years in government service or whatever. They will email me at my personal email address. I immediately forward the email to my state email address along with any division heads that I want to take action. So my way of dealing with it is I automatically just forward those emails so it's on the state server along with the department heads to whom they need to give me counsel on that issue. And I would suggest to you that when you think about you just won re-election, when you think about you like Tony, a very active newspaper in that community, if the newspaper finds out you're using personal emails to avoid the Open Records Act, it will not be pretty. And you'll be making a big mistake politically when it's time for re-election because you can tell already what the editorial will be.
My name is Cindy Mills with Forsyth County. I have a question concerning the intent of videotaping of meetings. I understand that every citizen has the right to videotape, but do they also have a right to come in before the meeting starts in the reception area and videotape private citizens as they're having conversations? Maybe it's a vendor talking about how they want to present, or maybe it's, lots of times it's companies that maybe are strategizing or trying to decide what they're going to present at a work session. And I've just noticed, and it goes up on YouTube, and I just worry.
I can tell you the lady who does it. I get emails from her twice a week. Okay, so number one, your lawyer's in the room who, as I mentioned, is a really good local government lawyer. It's not like you don't have an office, ma'am. There's no reason why that discussion needs to be happening in the anteroom before the meeting. It's really interesting because videotaping was the old law. Videotaping was not markedly changed in the new law. It was permitted then, it's permitted now. What has been done both times is you have to make reasonable accommodation. In other words, you can't put a camera in a room that obstructs the view of others. So, for instance, in Cobb County, we had an area to the side of the room that we would tell anyone with a camera, put your camera right there. Get a great view of the commissioner, see my good side, and film all you want. But you can't be like in the middle where you're blocking other citizens' views of the scenario. You know, the ante room is public. So technically they have the right to have the camera there. You're the one choosing whether to have that kind of a discussion there, and I would suggest maybe the discussion shouldn't occur there.
But I didn't mean a commissioner, not a public official. I'm talking about people, business people.
Understood. It's a public space. The question isn't whether I think that's good policy or bad policy. It's a public space.
Good morning. Right here.
Hi.
How are you? Carvel Lewis, Georgetown, Quitman County Commission. If and when a commission decides to get or change county attorneys, what are some of the checklists or things just off the top of your head that we should consider or they should consider?
I would suggest to you that the top of that list wouldn't be their hourly fee. You get what you pay for, oftentimes. I would suggest to you that you put an email out, and Jim, you tell me if you disagree with me. What I would do literally is I'd call Jim Grubiak or Ross, and I would ask for the next email blast or print material on ACCG government, say, Quitman County seeks to hire an attorney, and that there's an email address to encourage folks to apply. I would go to other government sources that Ross and Jim may tell you about to look at lawyers. I will tell you that if you go up to someone like a Ken Gerard, they're going to tell you, you know, there's a lawyer in your section of the state that's really impressive, and you might want to talk to him. A lot of that stuff is going to be done by talking to other folks who do local government law. I don't think a blast in the AJC or the Valdosta Times accomplishes anything. You're going to get more from dealing with ACCG and from dealing with other government lawyers, and they will frankly be more than happy. I mean, Ken represents numerous governments. They all think he does a great job. He's not going down to Quitman County because you're too far from him, but he'd be happy to sit there and give you some advice that would be helpful. Same with Jim. He's going to know lawyers around there. Yes, sir. Did I do that okay? Okay.
This is going to be a little off topic, but I'm about to be faced with an issue at swearing in concerning the oath of office. We had a situation recently in Gilmer County where the district attorney decided that the commissioners cannot be bound to the county charter because even though our county charter says that we should take an oath swearing to uphold state, federal, and local laws, the commissioners only take an oath swearing to uphold state and federal laws. Mm-hmm. So what I'm wondering, since the county charter is created by the legislature, is it not a state law? And are we not bound to it by taking the standard governor's oath?
Okay, so candidly, every local government has different nuances. So for instance, when I took the oath, by being chairman, I was automatically a member of the Water Authority. I took some different oaths on the Water Authority than I did to be chairman or commissioner in Cobb. So the answer isn't as clear as you are suggesting it might be. So here's my card. Send me an email, and I'll have my folks get back to you as to how to get the right answer to that question. Okay? A lot of basic legal questions don't have really clear legal answers, but we'll help you on that. Okay? Mm-hmm. George, what's George's last name? No, not George Anderson. Excuse me? McClellan, yeah. But believe me, I know and I'm friends with a bunch of them. I mean, I know the active folks. When you go up to me and say, when the lady from Forsyth says, we have a lady, believe me, I know her name. Because they contact me on a regular basis. I have a little fan club on your issues, you know. Yes.
I'm Lynn Lauder from Whitfield County.
From which county?
Whitfield.
Sure.
And this probably is going to be too basic of a question, but I'm having trouble in my mind between the open meetings and the open records. And open meetings, I understand, is among commissioners and when you could possibly be conducting county business. But we've had a zoning issue already that I've been involved in, and I went and met with both companies and heard what their side of the story was. So are private citizen things public record?
No.
But if I email those private citizens,
Technically,
It's-
until you're sworn in, it's still private.
okay, but after I'm sworn in,
Then
is
it's a public document.
any communication with a private citizen,
Mm-hmm.
but can I go talk to them and that's not public record?
Well, there's nothing to show them in return for the talk, because it's
Okay.
oral.
So it's all written. It's
Yeah,
not-
I mean, you'd be amazed how few times people request records like that, because they candidly don't want to write the check. And of course, people have the right, I should have mentioned this, people have the right to review the information without paying the 10 cents per page. But I would suggest to you, if you're doing your job right, don't worry about the open records request. Because unless you're putting stuff in those emails that you shouldn't be putting, if you're encouraging input, if you're asking questions, that's all fine. It's when you start saying, well, my opinion is X, or I'm going to vote X on that issue, that's when you get yourself in trouble, which leads me to the following comment. You know, we used to do town halls, and, like, for instance, there's a picking on Charlotte. I presume there's, numerous divisions of business associations, chamber groups throughout her large county. And, I'd go as the county chair and I'd speak. And I'd look in the meeting, and to my surprise, 2 other commissioners would be there. Well, 5-member board, I got 3 commissioners in the meeting. So what I would say when they'd introduce me, I'd say, welcome to the illegal meeting of the Cobb County Board of Commissioners. And I'd say, I did not know that a majority of the board would be here. A majority of the board is here. It's not right for either of them to be told they need to leave. So these are the ground rules. You're not going to ask me how I'm going to vote on an issue that's coming before the board. And they're not going to answer how they would vote on an issue coming before the board. And I'm your speaker. I'm going to be talking. If they want to make a comment, that's fine. But it cannot relate to how one is going to vote on an issue before the board. So it overtly does not get us from the gray area to the obvious public meeting area. And normally when I would do town halls and all, there'd be a member of the local newspaper there. So in Charlotte's case, the Gwinnett Daily, and everyone laughs and everyone understands that those kind of things happen. But when you sit there and someone says, so I have a concern about, are you going to privatize the airport in Gwinnett County? The answer is, I'm not going to talk to you publicly about that. Because that would be a really stupid thing to do, whether there are other commissioners or not. And when there are other commissioners in the room, you're overtly looking for a problem to answer that type of question. And you have the out that from an ethical perspective under Georgia law, you should not be answering those questions publicly. So always take advantage of the ethical outs you have, which is you wouldn't want me to say something here that would frankly violate the ethical laws of our state. So if you want to give me information, if you want me to express some concerns I have, that's fine. Don't ask the question in a more direct manner because it hurts the process from a legal perspective. So from your perspective, as long as you're responding to the constituent and you're literally saying, I thank you for your opinion, I have concerns about X and Y, I'd love to get more information on it. If someone wants to send a document request to you, you're not going to get hurt by that. You're going to get hurt if you start showing favoritism to some folks versus other folks, that type of thing. And that's the golden rule again. That's just treating everyone fairly.
Yes, Audrey Chalker from Glasscock County. We have already been sworn in. Is that legal, or is there a certain day or time that we should be sworn in?
It's fine for you to already be sworn in, but you aren't technically in office until January 1.
Yes, we
By
realize.
definition, you don't really want to all show up midnight January 1 to be sworn in,
No.
unless there's really good food.
Well,
So
we just
it-
realized so many others had not been sworn
Yeah.
in. We just wanted to go by the book.
No, it's perfectly fine. It doesn't take effect until until January 1. In Cobb right now, I'm getting invited to, the DA's one day and the clerk of court's another day. It just doesn't take effect until January 1. Yes, sir.
Bill Watson from McIntosh County.
Sure.
Really dumb question, but I mean, are we
There are
saying?
no dumb questions.
I think you've had a lot of people anxious here in the room probably at this point, but are you saying that one of our constituents, if we're approached or if we go to lunch with them or something and we're asked about an issue, that we're just supposed to say, hey, that we'll be taking that up in the next board meeting? I mean, how far does our opinion go, or can it go, or how far is it not supposed to go?
Okay, so I would suggest to you that the answer to my question has nothing to do with me being the state's lawyer. And I would suggest the answer has to do with good politics, okay? And the answer is you listen to your constituents often, often, often. You should not ever be telling them how you're going to vote before that public hearing. It is free to have a good discussion, to ask them questions, etc. As a policy perspective, you should never go over the line of the action you're going to take at a public meeting, separate and apart from the ethics code, separate and apart from House Bill 397. It's just a bad thing to do politically from a public perspective. I meet with folks all the time. I used to have breakfast meetings pretty much every day when I was chairman of the county. I'd have lunch meetings a bunch of time. Accessibility is everything. But that doesn't mean you tell everything on your mind to the constituent or the business you're meeting with. And let me suggest to you, the worst thing you could do is tell them where you're headed, and between that day and the meeting, you meet with other folks and you change your mind, and then they think you're a blank, blank, blank. Because you went the other direction. Then you were bought and paid for. In between, they tried to buy and pay you. So that's just good politics to not go there. You may not catch that your first 3 months in office, but you'll catch it thereafter. It's really good advice. You're there to listen, and after you listen to everyone, you're then prepared to be voting when those matter. I mean, there are a lot of times I was headed in a given direction and then public comment would change my opinion, or I'd put extra stipulations on a zoning meeting or ask staff questions, and if staff couldn't answer them the way I was comfortable, I'd ask for a motion to hold until our next public meeting on something. It's not a rush to judgment. It's a good decision that what the public wants. So I think that's just good policy, separate from me being the state's attorney. And let me go to your first comment there. My job is not to make your life miserable. I mentioned this to you before. We get over 400 complaints. I got 4 folks in the section. I want you to follow the law. I don't want your complaint in my office. If you have a concern, call my office. First, call your county attorney. But if there's still an issue, call my office. I'd rather take your question, have someone in my office take the question if it's one that we're comfortable taking, knowing we don't represent you and represent state executive. I'd rather be on the front end saying, can I do X or Y, than after you've done it and created the problem. So view my office more as a potential resource than a sheriff, because it works best for both of us if we can actually assist you rather than just be perceived of as, the sheriff coming to clean house. I'm not looking, even if I get a fine from you, it goes to state general fund, not a penny goes to my budget. There's no gain for me. My gain is just good government. And if you come up to me on the front end, we're all happier. There should not be a fear factor. There should be a, let me get the benefit of their insight. Okay? Yes?
Billy Zorn, Irving County. That last session right there, that question was asked was the best question been asked this whole week. And I thank you for the advice you're giving us for that, and to him also.
Thank you.
Because I had already decided earlier I was going to get a bad case of lockjaw. I mean, that
Look, you need to be responsive.
Thank you.
But you need to tell folks that, I used to tell folks all the time. I mean, I wasn't the brightest in the world. I'm still not, but you learn over 12 years of being in local government. Someone will tell you one set of facts today, and you'll get another person that will say, well, that was really good, but let me tell you what the real facts are. And then you go back to your experienced commissioners, you go back to the county attorney, you go back to the county manager or whatever, and not everything that everyone tells you happens to be true. And the more you opine on a final decision when you may not know all the facts, the worse position you're putting yourself in. So you need to be responsive. But look, as I told our new commissioner in my county, there's nothing wrong admitting I'm the newbie. I'm on a learning curve. Let me take your question to the department head and I will promptly get back with you. They don't expect you to know the answer to every question the day you were elected. They want responsiveness from you. So let me mention this little story to you. When I got elected as Attorney General, well, I wasn't allowed in my office day one because that's when we had the snow and ice storm and I didn't have a key yet and no one was there. It's a good thing my local sheriff, frankly, drove me to the Capitol so I could get sworn in that day. So day two, the office gives me a box of business cards. A box. Well, from my Cobb County days, I go through a lot of business cards. So I said, why are you giving me a box? Am I going to be indicted soon? And they said, well, we haven't had an attorney general before that was brave enough to put his email address on his business card, and we're hoping you'll learn really fast that's not a bright idea, too. To which I responded, order 2 more boxes, that ain't going to change. And for the gentleman that got my business card in row 2, I assure you my email address is on my business card. I also assure you that if you email me from our website, that email actually goes to me. Now, my assistant gets a copy of every email I get, which means I have 0 privacy in life. So I have like 10 different wives at this point between the office folks, etc., and my wife, 27 years. But accessibility is everything. People don't expect you to agree with them 100% of the time. They expect you to be professional and courteous and responsive. That's the whole key to re-election. It's not agreement, it's respect. I get votes and checks and all the time when I'm up for re-election from folks that say, I'm a Democrat, but darn, you're a nice guy. I want their vote. I want their check. It's all about handling yourself in a professional manner where the public thinks you care about them. And that's the best lesson you could have as a local government person. You can't walk in that local supermarket without being stopped. In fact, I might suggest if you could walk in the supermarket and not being stopped, you got a problem. I mean, yes. Yes. We're way over my time. Y'all we're supposed to have stopped me.
Jimmy Brett, Greene County. What if existing commissioners ask you to vote on a issue coming up in January?
Mm-hmm. Okay, so look, that happens all the time. In fact, I mentioned to the new commissioner from our county that if she ever called me on an issue, I'd give her one thing the other commissioners, the commissioners wouldn't give her, and that is I don't want her vote in return. Your job is to listen to the facts. Your job is not to alternate votes. I'll vote for you on stuff in your area of the county. You vote for me on stuff in my part of the county. That works for 6 months, and then someone gets smart, and then all hell breaks loose on that county commission. So I would suggest to you that it's not pretty, it's not easy, but you weren't elected to follow the dictates of your county commissioners. You were elected by the folks that went to the ballot box for you. And that's what you need to do. Okay? So I appreciate it. I'm sorry I went a little late. I wasn't bright enough to pick up on the stop. Pleasure to be with you all. Thank you. Thank you.